Good evening. Good evening, ladies and gentlemen. Welcome, distinguished guests. I'm Jenny Morgan. I'm the Dean of the Law School while the university engages in an international search for a new Dean. And it's a pleasure to welcome you all to the 2017 Peter Brett Memorial Lecture. I would particularly like to acknowledge the presence of the Brett family and welcome them, our distinguished guests, and of course our guest speaker, Dean Strang. I'd also like to acknowledge Professor Jack Anderson, who will be chairing or running the question time at the end of the lecture. I'd like to remind us that we meet today on the traditional lands of the Wurundjeri people of the Kulin Nation, and pay my respects to their elders past and present. Tonight's event, as you can tell from the title, forms part of the Peter Brett Lecture Series. Peter Brett was appointed Senior Lecturer at the Law School in 1955, Reader in 1961, and Hearn Professor of Law at the University of Melbourne from 1963 to 64, and Professor of Jurisprudence from 1964 until his death. He was distinguished both by his scholarship in criminal law and in legal philosophy, and his determination to contest injustice in the courts. So it's particularly apt, our particular speaker tonight. And I just want to say a few words about him before I invite him to give this evening's lecture. Many of you may know Dean Strang from the documentary series Making a Murderer. And I just want to make the comment that this is probably the first time I've prepped for one of these public lectures that I'm introducing, because I was told, it's the Making a Murderer man. So I watched Making a Murderer, and I told Dean this, and he said, well, that's a lot of time. I didn't go on to say, but I was absolutely gripped by it, and it was my evening's entertainment. So I do highly recommend the documentary to you, and Netflix is not paying me. So you'll know him from that, many of you. What you may not know is that he practices law in Madison, Wisconsin, in a firm called StrangBradley. He was Wisconsin's first federal defender and has argued in the United States Supreme Court, 5 federal circuit courts, and the Wisconsin Supreme Court. He's a lecturer on the adjunct faculty at the University of Virginia School of Law and has been an adjunct professor at both the University of Wisconsin Law School and Marquette University Law School. He also lectures in legal history for the University of Wisconsin. His first book was Worse Than the Devil, Anarchists, Clarence Darrow and Justice in a Time of Terror, and his second book about the mass trial of IWW members in Chicago Federal Court in 1918 will be published in 2018. So you can see he's got an historical bent as well. We're very grateful to Dean Strang for kindly agreeing to deliver this lecture and share his wealth of knowledge. So over to the lecture. How can you defend these people and other questions of humanity, humility and the humanities? Thanks, Dean.
Well, thank all of you, and Dean Morgan, the Brett family. It's commonplace to talk about what an honor it is to offer a talk or a lecture. So I fear I couldn't give the sincerity that I actually feel about this opportunity tonight. That Austin and Carolyn Evans and Jenny Morgan were kind enough to invite me down to Melbourne and all of you to attend. In the main, I think that my comments tonight turn out to be something of a meditation on the opening premises, the foundations of a talk that a former Chief Justice of the Australian High Court gave just over 6 years ago. Now, his talk went on to become quite descriptive of the history of legal education. Mine instead, I think, will be very lightly prescriptive toward the end of the future, possibly, that we might consider for legal education. But speaking on the 4th of July, 2011, to a conference of law professors about the balance between skills training, doctrine, and justice that he saw as necessary in legal education, recently retired Chief Justice Robert French, as you probably know, is a companion in the Order of Australia and was Chief Justice of the High Court, observed toward the beginning of his remarks as follows, and I want to quote him at some length. "The complexities of the question, what is justice, are illustrated by the simple example of the infamous dinner party inquiry, how can you lawyers represent somebody you know is guilty? Any answer to that question requires explanation of competing principles at work in the administration of criminal justice, that the guilty should not go unpunished, that nobody should be found guilty on the basis of an official assertion of guilt expressed in the laying of a charge, that the lawyer is engaged to represent and not to judge. The explanations rarely satisfy the interrogator, particularly if the respondent lawyer is representing somebody obnoxious. Any legal education worthy of its name should prepare the law student to answer that inquiry, not just to deal with the tedious interrogatories at dinner parties, but also to enable him or her to have a better understanding of law in society." And as I say, Mr. Chief Justice French went on from there. I want to pick up the challenge tonight that Chief Justice French offered at both a specific and a more general level. I want to consider first the question that he used as his example. How can you represent those people? Criminal defense lawyers, at least where I'm from, hear this often enough that we simply refer to it as the question. So I want to consider that question specifically as a lawyer of more than 3 decades experience now, mostly in criminal defense, not to offer my own answer, but to offer any help that I might to law students, younger lawyers, and people who pursue other callings in life so that they might confront the question anew, afresh, and perhaps in a more structured way. And then I want to turn more generally this evening to the connections between the question and the practice and study of law. So in the hope of offering help in coming to an answer to the question and then addressing the broader pedagogical issue that Chief Justice French raised, I'm going to start by framing 4 considerations embedded in that question. I then will turn to the broader implications for legal education and for our lives as lawyers. The question really begs us to consider both our humanity broadly as lawyers and as a nation and a culture to which law is intrinsic, and the specific quality of humility that the truly humane inevitably possess, I think. Both humanity as a broad quality and humility as one trait or manifestation of humane virtue lead us to consider the linkage and the importance of the humanities in legal education. Addressing initially then the question that Chief Justice French called to mind, I offer 4 considerations. 1, why is the question important? 2, Why must we respect those who ask it? 3, what will our answers reveal of us, whether as law students, lawyers, or as I say, people in other pursuits? And 4, will we implement and live in our answers? So first, why is the question important? I think it's important because it reveals so much about the questioner. And because it is such a common question, therefore it reveals a great deal about many of us and about our culture. Consider the question slowly. How can you represent those people? It's never framed as my people, never even our people or one of us. Alienation, a need to assign the accused as the other, is embedded prominently in the question. And implicitly but unmistakably, the question rests on the belief that both questioner and you, being interrogated, are above, are superior to that other, above, superior to those people. You and the questioner are the unstated we, having a side conversation on the sly, out of the earshot of those people. The question wouldn't be put to us if you or I were one of them in the eyes of the questioner. So the question is important in part because it lays bare the widely shared supposition that we do not commit crimes, they do. That we, therefore, are in a sense better than they. And that you, implicitly, are committing something like class betrayal by coming to their aid. Because after all, we need protection from them. The question really denies implicitly but completely a nearly universal truth, at least in a nation, highly developed laws like yours and mine. And that nearly universal truth is that we all are criminals. We all are criminals. You are, I am. The difference between we and they mostly is that we haven't been caught. Or if we were caught, we had the good fortune to receive some lenient treatment that didn't stymie our life prospects or deflect downward the arc of our possibilities. When I say we're all criminals, I don't want a show of hands. I don't. But an awful lot of people in this room, I suspect, have smoked pot, have tried cocaine, other illicit drugs, have driven drunk at some point. Maybe have had sexual contact in their youth with somebody who was too intoxicated effectively to consent. We've vandalized playgrounds or an opposing school's property. We've bootlegged music from the internet. For many of us, for some of us at least, worse than all of that. Parenthetically, if you're interested in pursuing that idea of near universal criminality, I would commend to you the work of a former Minnesota public defender named Emily Baxter, who runs a nonprofit organization in the States called weareallcriminals.org, and which has a pretty good website. And Emily speaks widely, and she's got a quite lovely coffee table book or book of photography out addressing this in both text and picture. But that, in any event, I think is why the question is important. We live in a culture of near universal criminality, but who gets prosecuted? Who actually gets prosecuted or apprehended and prosecuted, and why, remain the really lively questions. Not who are they, But who do we imagine culturally is included in that alienated group of those people? And why do we treat them as alien? The second consideration, I think, embedded in the question is that regardless what you think it reveals of the questioner, I think we need to ask why the questioner must have our respect. And for me, the core reason is they must have our respect because any one of us might have asked the question ourselves at some point. Many of us probably did. Certainly, some of the people we love do ask that question. The questioner almost certainly is unaware of the assumptions embedded in the question, let alone how unsound they are. The questioner may assume, rightly, that she never would commit a serious crime. She doesn't necessarily know or realize that there can be no guarantee that she will not be accused of a crime, falsely or mistakenly. He doesn't know that he or someone he loves one day suddenly may well become one of those people. He doesn't realize that someday he or someone close to him will need a lawyer. And lawyers, we lawyers, may not realize that we also will need the questioner. We will need the questioner as a juror someday, someone we must reach and persuade rather than scoff at and dismiss. We'll need the questioner as a judge, as someone who holds our client's immediate future and maybe long-term future in her hands. We'll need the questioner simply as our friend or ally. We cannot cure, after all, the alienation inherent in the question by treating the questioner as alien to us or to our values. We cannot address the implicit sense of superiority in the question by treating the questioner as morally or intellectually inferior to ourselves. This is why I think we really must respect the questioner, have the humility to do that. Third, what will our answers to the question reveal of us? Do we crave the status quo, the stability of the world as it is, the way I think many prosecutors and many judges do? Or do we take our chances with change, even chaos, on the belief that our world today is only a rough penciled sketch of what it could be and what it should be if we all lived a greater commitment to the humanity of everyone and to assuring the stake of everyone in our shared earth? Do we think that police violations of fundamental law are a regrettable but small price to pay for social order and for safety from those people? Or do we think that the lawlessness of those acting with the vast power of the sovereign is a greater threat to liberty and to our security than any crime by the poor or by the individual ever will be? Do we look at the racial, ethnic, and class disparities surrounding us in courthouses, courtrooms, and the entire criminal justice system, and do we say how, sympathetically, how unfortunate all of those disparities are? Or do we rebel against them, urge action against them, even when that will threaten the status quo? Are we willing to take action ourselves to address those disparities? Our answers to these subsidiary questions and others, all wrapped up in answering the question, fundamentally determine who we are and who we will be as lawyers. This is what our answers reveal of us. Fourth, and finally, revealed this way by our answers to the world, to our families, our friends, our adversaries, judges, colleagues, employers. Will we live with and in our answer? Will we befriend the friendless? Will we stand alone, if necessary, in defending the universally detested, man or woman? Will we separate the human being who is our client from the inhuman act he may have committed? Will we alone, if necessary, be unwilling to judge him only by the worst thing he's ever done? Will budding sympathy for our clients and for their victims eventually grow into a mature and deeper empathy for the entire human family? Will we eventually come to live with the knowledge that there is no us and no them, that the very premise of the question is false? For there is no those people, there is only we. Will we in the end, then, get to the point where we restate the question something like this: how can I not defend my people, our people? If and when we get to restating the dinner party question in some way like that, we are defenders. Even if we never practice criminal defense or are not a lawyer at all, we are defenders. We will be defenders of all that is best in Australian life and law and culture, in American life and law and culture. So now I want to turn from that specific question, as I promised, to the more general topic of how we help one another, students, lawyers, and citizens, come to that conception of life and a lawyer's role, and how we equip ourselves to give back to a society that affords lawyers the great privilege of an important role in almost every aspect of life, cradle to grave. I consider the relationship here of humanity, its included quality of humility, and finally the humanities, each to one another and together to the question with which Chief Justice French and I started. So humanity. At bottom, what is any good answer to the question I've just been exploring a bit? What is any good answer to that question? And what are the considerations embedded in it, if not an expression of shared humanity? All inhumane people, after all, are incapable of defending anyone else. They usually are capable only of attack, for humanity is an affront to them and to their inevitable lack of self-esteem. What real footing, after all, has esteem of self other than the recognition of self as both human and humane, and thus necessarily the reciprocal recognition of other humans in self and self in others? The inhumane person, by definition, cannot ground esteem in the humanity that makes us human, and thus must seek esteem, I think inevitably a futile search, but must seek esteem in things external to self and external to other human beings, in money, in power, in praise, all of which are ephemeral, none of them eternal as the qualities of humanity are. And all of those things in which the inhumane must seek some sense of self-worth or esteem, all of those things are contests for money, power, praise, whatever it is, rather than collaborations with others. When we defend, in the way I've sketched it broadly, when we defend, we erase alienation. We defend not just one person, but a system of shared values that encompasses that person and all of us. We defend, then, not the worst that any one person can do, but the best that a society can aspire to be. In defending one human, just one person, we defend all of humanity itself. Done rightly, the humanity of the accused, the humanity of the victim, the humanity of the public as a whole. An adequate understanding of and answer to the question, I think, is inseparable from a broader quality of humanity. Now, the included trait that I've singled out is humility. And I think there's a reason that humanity, or humanitas in Latin, and humility, humilitas in Latin, share the same Latin root, humus. The root word means earth or decomposing soil. All humanity, of course, is temporal, earthbound, less than godly. In ancient thought, a creation of God like the earth itself and of the same earthly materials is what a human being was and is. The humble view themselves as close to the earth, to earthly affairs. They make no claim to godly elevation or that they exceed anyone else, for all humans are on the same plane, the plane of the earth. All of us have our toes curled in the soil, from the perspective of someone, I think, with humility. But beyond etymology, isn't it true? Isn't it just simply true in your experience that all of the really humane people you know and have met also embody a quality of humility? As they demonstrate true empathy and understanding of others, as they demonstrate an understanding and acceptance of the flair and the flaws, the altruism and the avarice, the soaring soul, the sinking spite, all those things that make us human. And as they accept the fact that these qualities make humans potentially different from all other animals, the humble person, those with humility, invariably do not exalt themselves for their humane capacity. They view themselves as merely engaged in the project of collaborating with other human beings around them in making the world a little better. They place themselves neither above nor below any other human being. And indeed, characteristically, they recognize the place and the worth of all other creatures whose existence depends on the enlightened humanity of one dominant species, Homo sapiens. So now to the concrete connection to the law and the question that humanity and humility have. As one small subset of that species, Homo sapiens, those of us who study, practice, or teach law, we must ask questions much broader than the one often asked of us. For one, as either Australians or Americans, we must ask what we do in a classically liberal society when faced with uncertainty in our justice system. If we're committed to both justice and liberty, what do we do when the search for truth does not yield confidence that we have found truth after all? For anyone here who might be seduced by the rise of forensic sciences or technology in policing and in the work of courts, seduced by our propensity to suppose that either technology or the natural and social sciences, whether that's DNA testing, ballistics, videotaping, behavioral psychology, or some other discipline. If any of us believe that technology or science today ordinarily produce certainty about guilt or innocence, it's simply not so. Usually science and technology do not provide anything close to certainty in trials. Rather, in most cases, outcomes actually depend on the hazy identifications by witnesses who had a second or two to observe and often were scared to death or under the influence of something, on dubious claims of accomplices seeking to avoid or reduce their own punishment, on the contestable credibility of many witnesses, on inference from circumstances and on the work of police officers who sometimes pursue their own hunches and preconceptions with less than fully objective rigor. In short, the accuracy of many outcomes in the criminal justice system simply is uncertain. The problem is how we reconcile ourselves to this uncertainty and how we administer something like justice consistent with liberty, justice being a quality that I think all humanity seeks, and liberty being a quality essential to humanity. How do we do that when so much remains so uncertain so often? I think that one answer lies in this same included value, humility. And humility really has not had, at least where I live, humility hasn't had much applied acceptance or displayed acceptance among police officers, prosecutors, defense lawyers, judges, really almost any of the actors in the institutions of criminal justice. So what do I mean exactly here by humility in this context, in the administration of justice, and therefore the linkage to liberty of humility? Let me tell you a story, just a quick story about another appellate judge, this one an American. In 1940, as war again was engulfing Europe, the United States Congress declared the third Sunday in May, I Am an American Day. The day was to celebrate those native-born citizens who reached the age of majority that year and now could vote, and equally was to celebrate those immigrants naturalized that year who now could exercise the privileges and duties of citizenship, I should say. In 1940 seems to me at this moment such a long time ago in terms of my nation's excitement and enthusiasm about welcoming immigrants and welcoming them to the privileges and duties of citizenship. But be that as it may, after the initial declaration of I Am an American Day, celebrations in following years grew, especially in cities like New York, which were large and also home to many, many recent immigrants. On the fifth celebration, the fifth anniversary of I Am an American Day, 21st of May, 1944, New York was under blue skies. The temperature rose to 72 degrees as I think of measuring temperature in Fahrenheit. 14, 15 Celsius, something in that, I don't know, 18 maybe. In any event, it was a lovely, lovely spring day, that 21st of May. A million people had gathered in New York's Central Park to celebrate the day, and the keynote speaker was an unlikely man. Short man, stocky, sort of rugged good looks, bushy eyebrows, but a very quiet and reflective personality. It was a very unlikely honor for him to be speaking that day. He was a federal court of appeals judge who sat in New York City, probably something of a social liberal in the privacy of a voting booth, but very much a judicial conservative on the bench. Every American law student comes to learn his name, usually in first-year torts or later in civil procedure. He was Learned Hand. Judge Hand gave a serious talk that lovely May Day, and a very short one that he called The Spirit of Liberty. In that short speech of exactly 600 words, Learned Hand said this to the hushed crowd of immigrants, soldiers, and young people gathered there on the lawn in Central Park. What then is the spirit of liberty? I cannot define it. I can only tell you my own faith. The spirit of liberty is the spirit which is not too sure that it is right. The spirit of liberty is the spirit which seeks to understand the minds of other men and women. The spirit of liberty is the spirit which weighs their interests alongside its own without bias. And that captures, for me at least, that captures the essential link between liberty and humility. Now, I don't confuse humility here as learned hand understood and explicated it with lazy ambivalence, with mere indecision, with fear to act, with a lack of vigor in our arguments. Not at all. Rather, this brand of humility is the recognition that while we must act and while we should hold firm principles and opinions, we also must remember simply that we are human with bounded experience, bounded foresight, and bounded rationality. So we could be wrong. We could be wrong in the end. Which should make us cautious, it seems to me, at the very least, about the consequences for others that we attach to our claims of certainty in the administration of criminal justice. In more than 30 years now, working as one officer of our courts, I too rarely see those who serve in the various roles of our institutions of criminal justice, which together make a system of justice. I too rarely see myself and others conducting ourselves with humility. I see more hubris than humility. Only infrequently do I see judges, prosecutors, defense lawyers, police officers living and expressing a spirit that is not too sure that we are right. So if a lack of humility compromises our humanity, as lawyers or others in the justice system, what can we do? And this brings me to law school and to the humanities. We are, after all, at a really world-class, wonderful law school. The oldest in Australia. Probably, in the view of many of you, the best in Australia. And what we should be doing here at this school or any law school is helping to enliven and enhance the humanity and its subsidiary expression of humility in the law students and lawyers who live here, among all other tasks that law schools also must undertake. So for guidance in addressing humility, humanity, and the humanities in the study and teaching and learning of law, I think, we've got pretty close at hand three good examples, actually. One is the former dean of this law school and now maybe vice provost of the university, Carolyn Evans. She's the one who initially extended this invitation to me. She's an eminent scholar on the place of religion in public life and more generally on the importance of legal regimes that leave worship and thus the human mind, spirit, and conscience free. She is, in other words, someone deeply committed to the humanities and has an academic background in and love for the arts. A second example, even closer at hand, is your interim dean, Jenny Morgan, a really accomplished scholar of feminist legal theory and the very real problems of violence against women and the intersection of gender violence and popular media treatment of it. I was talking with law professors at the University of Queensland last night who consider her book on hidden gender in the law as a foundational work in this area, and rightly so. She's a scholar within the humanities traditions. And third, we have with us in spirit the man whom this very lecture series honors, Peter Brett. He was an eminent professor of jurisprudence, which is to say philosophy, as applied to problems of law, here for many years, and he was an ardent proponent of interdisciplinary studies before that was current. All three of these examples, I think, are both products of and champions for the humanities. And I also think humanities critical to our understanding of law and to its study. That's why I want to leave you tonight with something of a caution that, at least from my perspective, the legal academy increasingly has, over the course of a century or more, really since the rise of the legal realism movement, slighted the humanities as it has become enamored of the social sciences applied to the study of law. Law schools should try to mint new lawyers, in my view at least, both prepared and motivated to meet a world in which justice and injustice are systemic problems. I think I stand here again with former Chief Justice Robert French, although he used the phrase law in society rather than systemic. For law schools, meeting the challenge of preparing lawyers to pursue systemic justice presents not primarily a skills or doctrinal mastery challenge. Surely skills and doctrinal mastery are important, but that challenge of preparing young lawyers to meet a world in which systemic injustice prevails is not first a skills and doctrine problem. First and more primarily, I think it presents a challenge of comprehension or conception of life and of the problems that dog clients throughout their lives, and of values. Skills, after all, matter hardly at all if the lawyer does not see the full sweep of the problems, understand their interconnectedness and nuanced causes, and have the will to bring her skills to bear for a client. Only if she comprehends the problems that clients face and holds a conception of life that impresses upon her the injustice, often in the web of problems that clients confront, will she likely value both her client and justice deeply and persist in law practice. So, as Robert French proposed, the dual challenges for the law school are to produce the student who has skills and a grasp of substantive and procedural doctrine, but also has a rich conception of justice, a student who is able to identify and articulate injustice and justice in thoughtful, persuasive ways. Legal education, though, as we know it now, or at least I know it in the United States, and I will guess perhaps here too, legal education now does a better job with skills than with the challenge of enlivening and deepening a conception of justice and giving some intellectual rigor to the consideration of justice and injustice as opposing concerns. Why is it that we do better with skills than with a rigorous or organized approach to discussing and addressing justice and injustice? Well, I can guess. I mean, that's all I can do is sketch out, I think, historically, maybe where the root of that gap or imbalance lies. My guess is that I would trace it back at least to a famous dean of the Harvard Law School, and somebody who's had an impact across the English-speaking world in the way we teach and learn law, Christopher Columbus Langdell, late 19th century dean of Harvard Law School. He made a number of changes in legal education and in the way law schools still work and still see their undertaking. But maybe the most basic of those changes is also the least examined. That is, his most basic change is not the case method that he pioneered and for which he's remembered best. It's not the debate that he and other formalists began with positivists. It's not the reaction of the legal realists to that debate. The deepest and most lasting change, I think, that Langdell made was his basic foundational belief that law and its study belong to the social sciences. I quote him in an 1887 address. "If law be not a science, a university will best consult its own dignity in declining to teach it. If it be not a science, it is a species of handicraft, and may best be learned by serving an apprenticeship to one who practices." Now the Harvard condescension drips from those words even 130 years ago. But he made his point sharply and eloquently. The idea that the law might belong to the humanities at bottom, not to the social sciences, that's an idea that probably, had we been able to ask them, great legal thinkers from Aristotle, at least through Locke, would have taken for granted, that law belongs in the world of the humanities. That belief is one that Langdell utterly rejected. Now, positivists have wrangled since the 1870s with Langdell's formalist idea that law could be discovered by scientific reading of judges' opinions or judgments. But positivists haven't doubted the premise that law is social science. Realists have had much the same quarrel with Langdell, but in the end, their dispute has been that he offered the wrong scientific discipline, or no clear scientific discipline at all, and that the right social sciences were sociology, political science, psychology, and maybe economics. Again, the realists in their day did not question the basic scientific premise that Langdell sponsored. Almost no one has questioned that premise since the late 19th century. And this social science conception of law really is very different than a humanities conception of law would be. It's the difference, in a sense, between objective and subjective. Here's what I mean by that. Objective. Now, broadly speaking, many of the social sciences, as our law schools abridge and apply them, posit the human being as an object or as a model, a construct that is partially dehumanized, and then seek to measure the behaviors and capacities of which that object or model are capable or display. So, in a sense, the behavior of the object or the model is measurable over time. The human being, or the sort of desiccated human being that is the concept here, is a black box whose conduct can and should be affected by external stimuli like legal rules or statutory incentives and sanctions designed by lawmakers for policy reasons which, by the way, are about which the social scientist generally is indifferent or agnostic. But it's an objective, outside-in sort of conception of the law's action on human beings and the measurable responses of human beings to the external stimuli that the law applies. The social science approach is also quantitative. It's empirical. All of this, by the way, very useful, critical in many ways to gaining insight into law, but not qualitative or normative are the social sciences as a rule. The humanities conception is in sharp contrast, subjective again, in a way. By subjective, I mean the human being is the very subject of all humanities. And a humanities conception of law would make the human being the subject of the law. That is, the law is and should be an expression of the truths learned in exploration of human nature and human experience. So the study of law under this conception would proceed not from the outside in, but from the inside out, from an exploration of what it means to be human, and therefore what law must do to serve and enrich the project of becoming fully developed human beings. And the humanities inevitably are qualitative or normative often. They ask not just what people do, but what law should do about it, and what people should do as a normative sense. Why do these conceptual differences matter? Well, I think in recent decades, the principal social sciences in law schools have been microeconomics, behavioral psychology, and political science. Again, is sort of abridged and applied by law professors. And this flattened and compacted version of social science leaves you, me, and students with fairly developed ideas and vocabulary for considering efficiency, efficacy, rational actors, least cost avoiders, cost-benefit analyses, default positions, nudges, primacy, recency, public choice theory, free rider problems, the parsimony or complexity of models, cognitive biases, and all of the other great tools for studying law or achieving insight into law that the social sciences have to offer. But this same social science perspective leaves us with few nuanced ideas about or much vocabulary for addressing in an organized way justice. Let alone does it hone the tools of persuasion, of empathy, of recognizing and articulating inevitable value choices in law and in judicial decision-making, of conceiving institutions to which we fairly might entrust collective judgments, or even of imagining legal proceedings with majesty and dignity rather than administrative, bureaucratic, efficient regularity. Whatever justice is, it is more qualitative than quantitative, I hazard to say. It's more normative than empirical. And so I'm going to end where I began, with Chief Justice French and his 2011 talk to the Australasian Law Conference, exploring the parallel roles of both skills or doctrinal competence and justice in legal education. I want to suggest that the young lawyer whose conception of law is confined to a law school abridgment of social sciences, or worse, to formalism embedded in much doctrinal study, might ask whether and how some of, let's say, Inspector Javert's conduct would be subject to legal challenge by a Jean Valjean or a Fantine. And that law student, again, imbued only of the social science perspective, might understand that legal challenge as requiring a balance of societal interests. Maybe in a reflective moment, she asks whether Javert's actions are an efficient way to achieve the policy goals of reducing theft and other crime. But the young lawyer whose conception of law instead has been expanded by or even rooted in the humanities considers, in thinking of the same book, why the poor are and why they remain that way. She tackles not just isolated problems of crime, rearrest, and parole revocation, or the lives of sex workers, or child custody, or abusive child foster care. But she also tackles the integrated systems and seeks to understand the integrated systems that ensnare today's very real Valjeans, Fantines, and Cosettes. This student sees modern, even timeless life in Victor Hugo's work and understands fully the footing that Hugo provides for Anatole France's later critique, that in its majestic equality, the law forbids the rich and poor alike to sleep under bridges, beg in the streets, and steal loaves of bread. We want our students and our new lawyers to embark with doctrinal competence and familiarity with the intersections of law, psychology, microeconomics, and political science. But we also should want more. If we can restore to interdisciplinary legal education a proper place for the humanities, for the philosophy that Peter Brett studied, and the other humanities, alongside the valuable social sciences, our law students and new lawyers then also could leave school with a sophisticated conception of and vocabulary for injustice and justice. I think we should want students to hear and recognize in Victor Hugo and in Anatole France's critiques a call to action as lawyers, to hear, see, and feel injustice, to know a reason to pursue equal justice under law for everyone, to know a reason to defend our people. Thank you. I'd be happy to take questions.
Good evening, my name is Jack Anderson. I'm a professor here at the law school. My job is very simple, to moderate the next 10 minutes of questions and answers. Just while Dean is getting his breath there, just to thank him, and we'll do this formally in a minute, for an informative and challenging and at times provocative lecture, and I think you'll agree with that. So we've only got 10 minutes. The way we'll handle these questions will be a bit like my personality, brusque and random. So we have roving microphones, and we have a question already.
Thank you very much. Catherine Walter is my name. I was in Professor Peter Brett's class back in the, dare I say it, 70s. Thank you so much for such a challenging and, dare I say, elevating address this evening. It was a great opportunity to hear such a thesis. When you spoke of us all being criminals, and I looked at the title of your speech, How Can You Defend Those People?, the question that crossed my mind, and you may regard it as rhetorical if you prefer, is how can you prosecute these people?
Well, rather than taking it as rhetorical immediately, I'll take it as very personal. I personally failed at prosecuting. I tried it for 10 and a half months and had to get out. It was my first experience with criminal law. It turned out I loved criminal law. I just had the shoes on the wrong feet. That said, I can tell you what I admire in a good prosecutor. And the fact that I identify good prosecutors and admire many of them, I think implicitly says, at least for me, there's room and a necessity in an ordered society for prosecution, for calling to account people who harm other people or inflict social harm more generally. And what I respect and admire in the good prosecutors I know is a devotion to trying to improve the lives of victims, trying to improve the lot of people who have fallen victim to crime, to do something to set it right, to do something to restore what the victim has lost. I admire in good prosecutors a constant sort of focus on a pole star of socially appropriate conduct and restoration of order and loss that's inflicted. I admire in every good prosecutor the quality of looking at my clients as human beings, not as monsters or something less than human. Now, many prosecutors do dehumanize the accused. It's easier to do your job in some ways, to not sort of acknowledge your own role in inflicting harm in the name of curing it. But the best prosecutors I know unflinchingly regard the people they prosecute as fully human, and their families as fully human, and indeed see the accused and his family as connected to the very same community the prosecutor seeks to serve. And thus the best prosecutors I know will listen to advocacy from defense counsel, will consider new information the police haven't brought them, and will amend their course or change, alter in some way their direction when new facts are brought to light. So we will always have prosecutors. I fear we'll always need them. I honestly, if I'm going to be confessional, when I happen to be teaching a course, I take more interest probably in those students who want to be prosecutors than I do in those who want to be defense lawyers in some way. I guess probably because I fear I've got more urgency in reaching those who want to be prosecutors and playing some role in helping to form them as lawyers.
Many years ago at a lecture, there was a professor who said to a very informed crowd of lawyers, what's the purpose of sentencing? And a very senior lawyer put up their hand and said, well, it's about punishment, deterrence, rehabilitation, and etc. And the professor said, no, isn't it about making a better society? And I wonder if you could think about that in the context of the thesis you've projected tonight and the problem that we face in Australia at the moment of overcrowded prisons because of increasing sentences of imprisonment as the only way to deal with the problem of making the community a better place.
We could talk for a long time about this problem, and I'm not trying to duck the question, but the aspiration that professor expressed a few years ago in the lecture, that sentencing ought to be about making a better society, is noble, and it's right. And the four sort of traditional aims of sentencing, I think, have in many ways outlived their vitality, or they're not alive anymore. They don't have much vitality. They've become sort of dry markers or incantations. I fear, and I have fear saying this too in this group, but I fear that beyond the aspirational, that often what sentencing really is about, although nobody intends it this way, it's about maintaining a social class structure, that the carceral state as, or in practical effect, keeps the poor, keeps those who are disadvantaged permanently disadvantaged, adds to the burdens they carry. And as you approach a state of mass incarceration, whatever that may mean, we've been there in the United States for a while, you are decimating whole communities by removal of people at too high a rate and for too long a time. Not just decimating those lives, and not just the lives of the little boys then who grow up without a father during critical years, and the mothers who've got to work two jobs to try to make ends meet. You're not just decimating families, but you're decimating whole communities as you're removing vast numbers of people from them for long times. So if we could pursue the aspiration that the lecturer suggested, it would include the effect on ourselves of the carceral state, the long-term effects and damage that we do to ourselves by the overuse of imprisonment as a response to crime. Overuse both in just the rates, per capita rates of incarceration, and the length of time. Now, nobody matches the United States in length of average prison sentence. Nobody in the world that I know comes even closer, at least among the Western democracies. But Australia is well above Europe and Scandinavia, and your average sentence lengths, I think, are growing. So it's a problem on your doorstep, arguably here, and the effects in the United States, I think, indisputably have been to maintain and reinforce underclasses and people who will never have a franchise, so to speak, in the society.
Thank you for your talk. From the title, I expected something very different, and I really liked what you said. But I found myself thinking while you were talking about the recent horrible events in Las Vegas, which I think test everyone's humanity. If that person who was accused and everyone believes did that crime was alive, I know what your answer would be to that question. The problem is he's dead, so he's beyond the law, and in one sense is literally indefensible. He can't be punished, he can't be prosecuted, but we are all going to judge him. Should lawyers play a role, perhaps as a group, in defending someone in those circumstances? If not, who should or is defending someone in that situation in light of victims and like a bridge too far?
Well, in my view, lawyers ought to play a role in defending the aspirations and values that a nation and a culture profess. And in the context of, Stephen Paddock, somebody who opened fire on people who simply gathered to hear a concert, people against whom he had no beef whatsoever. It seems to me, in thinking about how do we defend the best of our culture or defend the hopes and imagine who we can be and should be, defending our nation in that sense, we'd have to say immediately that this is not just about Stephen Paddock. It's about a culture that allowed him to acquire 23 assault rifles. It's about a culture that when brown-skinned people commit an atrocity, we speak of it as terrorism, and when a white man commits an atrocity, we're immediately talking about how mentally ill he must be, or how demented he must be. And we could go on a great deal about this, but I think the conversation has to shift to what American values really are, what future we want to imagine for ourselves. Have we entered into a constitutional pact that makes gunning down school children in Connecticut the price of one aspect of our liberty? Or is there a balance we can strike that will preserve the right to defend oneself, preserve the sporting options, hunting, for many survival requirements of hunting, but see fewer people end their lives as Stephen Paddock ended his, in that rage enabled by weaponry that made this possible, enabled by a society that makes it, whether we like it or not, thinkable that these things can just continue to happen. And it's thinkable, it's undeniably thinkable in the United States. Why? Because every time we have one of these mass shootings, the immediate response is, now is not the time to talk about gun control. Now is the time to grieve and to come together as a community. But in that deferral of the question of how to balance the individual liberty to bear arms with the damage that almost unrestricted access to any type of weapon and any form of ammunition has, the damage that inflicts on the larger society, on destruction of lives, and destruction of a sense that we can be better than this, that we don't have to tolerate 10 or 12,000 firearm homicides every year and triple that number of firearm suicides, that we can rise above all that. And that's, I think, the role lawyers can play in defending the United States we aspire to be, or the United States that looks like the values we profess, rather than looks like the carnage that we see regularly at shopping malls and now concerts and schools and homes. How's that for ending on a deflating, depressing note?
Thanks very much. Just to wrap up, by formally offering a vote of thanks, I was trying desperately to think how I would summarize this, and I just have two things to say. First of all, Harrison Ford, the very famous movie actor, has a son called Malcolm. When Malcolm was very young in kindergarten, he was asked the question that all children at kindergarten are asked, "What does your daddy do?" And he said, "My daddy's a famous movie actor. Sometimes he plays the good guy, sometimes he plays the lawyer." And what you've seen today is a good guy and a lawyer. And I think that there is no doubt about that. And I think when you look at the subtitle to today's talk, how can you defend those people? Well, I think the answer lies in your humanity and your humility. And thank you for the 2007 Peter Brett Memorial Lecture. And I would like you to offer your thanks generally to our speaker.